get here, he doesn't.
Hey, Sharon, if you can watch, just keep an eye on people coming in. I'm going to go to my meeting minutes.
I will indeed. We're at 29 right now. I don't think we have anybody waiting at the moment.
Oh, I got them. I can actually still see them out of the corner of my eye.
Okay. All right. Well, we'll both sort of keep track of them and make sure. Ah, there's Mr. Morse, ready to present. All right, it is 7 o'clock, so I am going to call the meeting to order. This is the Wellfleet Zoning Board of Appeals meeting for December. And our first case is 2117, the Mandell Family Realty Trust, application for a special permit to reconstruct a single-family dwelling on a non-conforming lot. The lot had been previously developed with a single-family residence, which was destroyed by fire several years ago. Proposed dwelling will conform to the current setback, and this was continued from an earlier application in order to go before the Conservation Board. And the board is myself, Trevor, Will, Mick, and Janet. And I believe, Mr. Karen, you're going to present for the applicant, right? So if you unmute yourself, you can begin.
Thank you very much, Madam Chairman. Can you hear me?
Yes.
Okay. Good evening, and members of the board. My name is Kevin Corain, and I have the pleasure of representing the prospective purchaser of the property, as well as the Mandell Family Realty Trust, who are the current owners of the property. The property is currently under agreement pending acquisition of all permits that are required in order to construct a single-family residence on the property. As the chairman has indicated, what we're proposing here is to construct a single-family residential structure containing about 2,520 square feet on this non-conforming lot. With me tonight are my clients and Stephanie Seguin from Ryder and Wilcox, who has done the engineering on this project. What is being proposed is a 3-bedroom dwelling. It is replacing a 3-bedroom dwelling that was destroyed by fire approximately some 4 years ago. The property has been in the Mandell family for about 100 years, and they have continued to use that property for residential purposes throughout that period of time until, unfortunately, they suffered the casualty that occurred back in 2016. The project has been before the Conservation Commission, and the Conservation Commission has issued an order of conditions. That order of conditions included requirements, or my clients had already proposed to include a denitrification septic system or denitrifying septic system. In connection with that project, there was significant plantings as part of a mitigation plan and a gray water process, which would be used to partially irrigate when irrigation might be required. That mitigation planting was not only on the lot, but also to stabilize the coastal bank, which adjoins the lot in question. My clients had originally approached the building department many months ago to discuss the issuance of a building permit. It was suggested to them by the building commissioner at the time that they would require special permit relief in order to reconstruct or replace the dwelling that had been damaged. The dwelling that had been damaged was non-conforming, and if you have a copy of the site plan in front of you, it's my understanding that the dwelling was situated in the southeasterly corner of that lot. A portion of the dwelling actually crossed the property line, or was built upon the property line as it relates to Meadow Ave and up against the property line on 10th Street. So what we are proposing here is to construct a conforming dwelling which complies with all of the requirements of the bylaw as it relates to setbacks, height, and lot coverage. As I said, we have applied for a special permit in order to do that. We believe that if the board requires special permit relief, it was originally contemplated that the building department could make an initial determination as to whether or not the proposed replacement was actually increasing the non-conforming nature of the structure. We don't believe that we're increasing the non-conforming nature of the structure that was destroyed, because we are in fact eliminating all non-conformities as it relates to that structure. However, it would appear that, at least in discussion with the original the building department commissioner that was in place at the time, that perhaps the special permit was being suggested because of the fact that it was construction on a non-conforming lot. As I said, that is why we're here. That is why we applied for special permit relief. We do not believe that we are increasing the non-conforming nature of the structure. And we do believe that under Massachusetts law and under the local bylaw, that the board would be within its discretion to be able to make a finding that what we are proposing is not substantially more detrimental to the neighborhood than the structure that is being replaced. And I would suggest that because of the utilization of a new septic system, meeting the requirements of Title V, including the denitrification component, the substantial mitigation planting, the elimination of the non-conformities that previously existed. Other than that, I really don't have too much to add to the discussion. As I said, the project has been approved by the Conservation Commission. So I believe the Conservation Commission, which is the board to whom the town has delegated the responsibility and obligation to protect the wetland resource areas and other coastal areas that are the subject matter of their jurisdiction, have granted a permit and believe that this project can be developed and properly conditioned so that we are not having any kind of an adverse impact upon those resource areas. There were issues at the Conservation Commission that were brought up relative to water quality in the area. It's my understanding, having listened to the Conservation Commission discussion, that there has been a long-standing water quality issue on the island as it relates to the intrusion of salt water into the freshwater aquifer in that area. We don't believe that the replacement of one 3-bedroom dwelling for another has any impact, let alone causing a substantial detriment to the neighborhood as a whole. With that, both my clients and Stephanie is here. If the board has any questions that they would care to pose, we're certainly open to that.
Thank you very much. Okay, I know that I have one letter from this, and it is from Ms. Kampas. And so I'm wondering if you want me to read your letter or if you'd like to speak to your letter, Ms. Kampas.
Good evening, Madam Chair. I would briefly like to touch upon some of the points made in the letter. I assume you all have read it, hopefully, and so I'll try.
I'm not sure that everyone has because of the because of when it arrived and not our inability to send it out. So you want to probably cover as much as you can.
Okay, thank you. That's helpful. Members of the board, my name is Jeannie Kampas. I'm an attorney at Nutter, McLennan and Fish. I represent Richard Thaler, who is also present here this evening. He owns the property that directly abuts the trust property. His address is 250 Meadow Avenue West on Lieutenant's Island. We did submit a letter. It was later in the afternoon yesterday. I apologize for that, but we raised 3 concerns in that letter, which I'll touch briefly upon here. One is a legal issue, one is kind of a mixed factual legal issue, and the third is a title issue. The first is a legal issue, and that is Seems clear from my reading of the bylaw that a variance is actually required for this project rather than a special permit. To be clear, there is no pre-existing non-conforming structure at the site. It is a vacant lot right now, and it has been for 4.5 years. Your bylaw has a provision, section 6.1.2, that allows pre-existing non-conforming structures such as the prior cottage at the site to be rebuilt, provided though that construction is commenced within 1 year and completed within 2 years. And here, as the applicant stated, more than 4 years have passed, 4.5 years actually, and it's still a vacant lot. You know, it's clear that the section in the bylaw, the intent was to place parameters on the longevity of this pre-existing non-conforming status that benefited this property. And so if you have this pre-existing non-conforming status, but it's destroyed status on a structure and the structure is destroyed, you don't have this unfettered right to rebuild at any time you want. You have to rebuild within the 2 years. If you seek to expand it beyond what it was, you can do so under your special permit provisions, but construction has to be completed within 2 years. Otherwise, you lose that status, and now we're left with a lot that's undersized by today's standards and lacks frontage, and it requires a variance for this project to proceed. The second point I wanted to go over, the applicant did touch upon, it's the groundwater contamination and the concerns for that. And he's right that the saltwater, or the content of sodium in this water in this area, has been bad for a while, and it will be exacerbated though by this project. It is a 3-bedroom house proposed, and it was a 3-bedroom cottage proposed. However, the prior cottage by your town records was 554 total square feet. This project is 5 times that, somewhere along those lines. This is a major intensification of the residential use at this site. So to say that there won't be an increase in water usage or that it won't have a detrimental impact on the neighborhood is frankly just unfair. It's not true. We have water test samples taken from various abutters, and the sodium content in those samples range from 660 milligrams per liter to over 2,400 milligrams per liter. The federal drinking water standards set a limit of 20 milligrams per liter. So you're looking at an exponential increase over what is recommended under federal drinking water standards. And I also note that in order to obtain a certificate of occupancy or a septic permit, both of which are required for this project, the applicant's going to have to show that they meet the federal drinking water standards. And based on the neighbor's water tests, I find it highly unlikely that they will be able to meet those standards. And finally, the third concern is a title concern. And I know the board is not charged with dealing with title disputes here, but the site plan shows an access easement, and that access easement benefits Mr. Thaler's property. The site plan also shows, and the applicant has stated before other town commissions, that they plan to unilaterally relocate that easement to accommodate this new structure. But Massachusetts case law is quite clear that they do not have the right to unilaterally relocate an access easement benefiting another property. Instead, they either have to obtain the agreement of Mr. Thaler, which they have not done, or they have to obtain a court order authorizing the proposed relocation, which they also have not done. And so if this board were to grant the relief requested and purport to authorize this project, including the proposed relocation of this easement, it would be legally untenable as a matter of law. So for those reasons, Mr. Thaler is respectfully opposed to this project. I don't think he's opposed to any development on the area, but he is really concerned about the water quality, his easement, and would like to see those issues resolved. Thank you.
Thank you. Okay, do I have others in the audience who would like to speak to this? Mr. Thaler, you can go ahead and unmute yourself.
There.
You were unmuted for a moment, but you're muted again. There you go.
Oh, great. Thank you very much. I appreciate this. And, you know, this is a problem to some extent. I'm sorry to say this, of the Mandell's making. They initially undertook a project to build a substantially smaller house. And then for some reason, unbeknownst to me, they ceased that process. And there was a period of time where nothing happened. And then I think some broker or somebody said to them they could make substantially more money by building a giant home on the property. Now, there's plenty of case law, which I'm sure you can read, that Jeannie has pointed out why this would require a variance. And it's recent case law, not ancient case law. And I would also say the water problem is one where the Mandells and their potential buyer have never even tested the water, or if they have tested the water, they haven't shown the results because the results are bad. When we went to the Conservation Commission, the McDonald's and I presented and can show you guys the water results that Ms. Kampas referred to. But it's not going to make it better. And we're talking about not a rebuild, but a house with a basement and an office that is bigger than the entire second floor of the pre-existing home. So it's very damaging. And it's not just me. Jamie Rice and McDonald's share my concern. Jamie wanted to be on the call, but he unfortunately had to call to Asia. He is in the money management business. But it is a genuine concern. We feel badly for the Mandells and wish they had built a smaller structure when they did. But at the same time, they're not going to be there, and we're going to be there with this giant McMansion if they go through. But we are comfortable that the state laws and case history is with us. It absolutely requires a variance, and we hope that you guys will look at that and concur with that. It's quite articulately laid out in the memo by Ms. Kampas. Thank you very much.
Thank you. All right. Is there anyone else in the audience who would like to speak to this project before I go to the board?
Madam Chairman?
Yes,
would
Mr.
you
Curran, yes, you may,
you prefer that I respond or wait until
yes,
after the board?
yes, you may respond.
Okay, a couple of points. I would point out that the case law that's referenced in the letter is non-precedenting case law. It's a case that was decided by the land court. I'm not sure whether or not that case has been appealed, but at any rate, land court decisions do not establish precedent relative to case law. I would also suggest that Mr. Thaler has represented this as a McMansion. By no stretch of the imagination is this a McMansion. It's has a footprint of less than 1,800 square feet and a total square footage of 2,520 square feet, I believe. So I don't think that qualifies as a McMansion. And last but not least, on the issue of the easement, which I don't believe is necessarily the proper subject matter for a discussion with the Board of Appeals dealing with zoning issues. That easement does not contain specific meets and bounds or dimensions other than to say that it's in the approximate location of a path that's shown on the site. I would suggest to the board that what is being proposed, even though there are some minor deviations of that easement, it is in the approximate location of that path or access way that is shown on that plan. And as I said, I don't believe that's necessarily the appropriate subject matter for the Zoning Board of Appeals. I do think that there are inconsistencies in the bylaw. I do believe that the bylaw section 6.1.5 does afford an applicant the opportunity to replace a non-conforming single-family structure. It does not distinguish between replacements due to damage or whether or not they're voluntarily knocked down. Even though I suggest to the board that the case that was referenced is not precedent setting, I believe that was a case that talked about a voluntary demolition of a dwelling, not a dwelling that has been damaged by fire or some other casualty. I also suggest that there are certain limitations that were in the restoration section of the bylaw referenced by Attorney Kampas that may be restrictions that a property owner might not want to adhere to. in which event I believe that section 6.1.5 would provide that property owner with an alternative approach of development. The restoration provision would seem to allow that building to be rebuilt as a matter of right without any input from any town authority, other than perhaps the issuance of a building permit. But there are provisions in there that says that it cannot be built any larger than what previously existed. And I'm sure that there are situations where there are structures that have been damaged in one way or another, that have been very small cottage type structures that an owner, given the assessed value of these properties that are in these areas, would want to rebuild outside of a footprint or in excess of the size of a building that previously existed. And I think town meeting recognized that in adopting another section of the bylaw, which I've referenced, which would allow non-conforming single and two-family residential structures to be altered. And as I suggest, alteration includes the word replacement, and this we suggest is a replacement of the structure that was previously damaged. And it's also sort of funny, and maybe I'm just missing something, but even the bylaw 6.1.5.2 says that conforming single and two-family residential structures located on non-conforming lots may be altered. And if you have a conforming structure that can be altered or replaced with another conforming structure, I question why a non-conforming structure that is being replaced with a conforming structure wouldn't likewise have the same protection. So I really don't have anything to add. I can't speak to the history of the Mandells and what they have done, other than I know that there certainly has been no attempt to abandon the use of this lot as a legitimate single-family residential use, which has been established for 100 years by virtue of their having secured both conservation permits and Board of Health permits in connection with an original redevelopment plan. So I don't have anything further to add. Thank you very much for your
Thank you.
time.
Okay, I see your hand, Mr. Thaler. I'm going to go to Joe. You'll need to introduce yourself as well as unmute yourself.
Hi, I'm Marion Fontaine. I'm one of the owners. And I just wanted to state that a little bit about the history of us trying to sell the property. We did try to build, and we did go to the Conservation Committee and the Board of Health for the permits that we needed. I believe the house was 1,500 square feet plus a little shed or little studio on the side. I think that was like 200 square feet. Anyway, we stopped with it didn't get as far as the zoning board of appeals because we decided at that point we were going to sell. And we never stopped. We hired a real estate agent right away, and we were with that real estate agent until she sold her business. And then we went with a company in Wellfleet. So we have not stopped trying to sell it. We just would like to see a cottage built, and we're not trying to do anything ridiculous, just trying to sell the property.
Thank you. Mr. Thaler?
One point I would make is why I called it a McMansion. Those of you familiar with Lieutenant Island, it's really two islands. This would be the largest home on the second island and the third or fourth largest home on all of the Lieutenant Island complex on the smallest lot. And it is, as you just heard, substantially different from their original intent. And Jeannie said, we're not against the home per se, but we're against one that is substantially damaging. And we do think that there's a burden of proof on these people to show that it is not going to be detrimental to the water. And so far, we're the only ones who have met that burden by showing the level of water. And I think Jeannie also points out some health issues, which they continue to just sort of pass over and slough off. And that's our big concern, because after the Mandells leave, we're going to be left there. We're going to be left there, maybe with no water. or really bad water. Thank you.
Mhm.
I
Thank
think
you, Mr. Thaler. Is there anyone else from the audience who wants to? Yes, Ms. Kampas.
I just wanted to respond briefly to Attorney Corain's points comparing, or talking about section 6.1.5 alterations to non-conforming single or two-family dwellings. The distinction here that he fails to point out is that here there is no structure on this property. Unquestionably, if there were a structure here and they were seeking to alter it by special permit, that would be a different story. But the point of the bylaws is to eventually eliminate nonconformities, hence the reason for the 2-year limitation in 6.1.2. I think when you read that in connection with 6.1.5, provided you reconstruct a structure that has been demolished within 2 years, you can do it by right under 6.1.2 if you're within those parameters, or you can do it by special permit under 6.1.5. But the point is, a structure has to be on the property. And once the pre-existing non-conforming structure has been eliminated from the property for more than 2 years, you lose that pre-existing non-conforming status. And that is the point of the bylaw, to eliminate these non-conformities. That's all.
Okay, thank you, Ms. Kampas. Yes, Joe. You have to unmute.
Sorry, I just couldn't figure out how to get my name up on there. It's my husband's.
Quite right. Mhm.
I just want to say that the shed is still there with well as the well and the pump, so it's not a vacant lot.
Thank you. Okay, anyone else from the audience before I go to the board? Yes, Mr. Bernardin.
Yeah, hi, I'm Mickey Tripathi. This is my wife, Mimi Bernardin. We're here to represent. We're in favor of the proposal. We are the ultimate buyers of the property. The property is being purchased immediately by a developer, and the plan that you have before you is actually our plan. We brought in our architect and worked with it. It's certainly not a McMansion. In fact, it is smaller than the neighbor's house. So I just want to make sure that misrepresentation isn't allowed to continue. But and to the point of the longevity, our intent is to live there for many years, and so we are just as concerned as everyone else is about the quality of the water. We've stayed on Lieutenant Island, all over the island for a number of years now, and we've found salt water all over the island, and so we fully understand that there has been a water issue. We don't think that what we're proposing is going to incrementally add damage to the water situation.
Okay, and sir, I think I need you to state your name for the
Yep,
for
sure.
the
I'm sorry.
secretary.
Mickey Tripathi.
Thank you. Thank you. Okay. All right. I'm going to go to the board, and I'm going to start with you, Trevor.
The only question I have at the moment is the point that Attorney Kampas raised, because that was the question I was going to ask. In fact, I had that section of my bylaw open when she brought that up, and that's section 6.1.2, which seems to apply exactly in this case. I mean, Mr. Corain said that 6.1.5 doesn't deal with structures damaged by fire. Well, yeah, that's because it's dealt with in section 6.1.2, which says that you have to rebuild starting within a year. So that kind of, I don't know, kind of throws a wrench in the whole works for me.
Okay. Thank you. Mick, you have to unmute.
Unmute. There we go. Can you hear me?
Yep.
Okay. Yeah, I got the exact same concerns as Trevor. I don't see how we can move forward with this because it has not gone within the 2-year period, and I think we're bound by that, and I just don't see how we can move forward with this application.
Thank you. Will, wherever you are.
I'm here. I have a question of Attorney Corain, and it's this. I noticed when I first read this application, what was missing was any reference to what section you were asking relief from, because as I see it, the zoning board, a zoning board of appeals can only grant special exceptions when the bylaw allows them to review special exceptions. And so there are quite a few lots in Wellfleet that are undersized. They're non-conforming, just empty lots, you know, growing trees. Are you aware of any provision? The reason why I'm asking is I view your application since 4.5 years has run since the building burned down. I view this as an application for a special exception for a vacant lot. And there's lots of vacant lots in town. So are you aware of any specific bylaw in the town of Wellfleet that would allow an owner of a vacant lot to come into the zoning board of appeals and ask for a special exception? I mean, a special permit. Because that's how I view this application is, as I would view any other landowner in town with a substandard lot that was basically vacant, shed aside to construct a house. And I don't see it, but maybe I'm missing something.
Well, if you were considering this lot,
You're muted again, Mr. Karen.
if you were to consider this lot a vacant lot, then I would suggest to the board that it's likely that this vacant lot has grandfathering protection under General Laws, Chapter 48, Section 6, because it has remained in this family for 100 years. And to my knowledge, although I can't speak specifically, the abutting properties were not owned by the Mandells when the zoning criteria changed. And I do believe that because of the inconsistency in the bylaw, that the unusual inclusion of the word replacement, I think, would allow for the structure that was knocked down to be replaced, provided we met the criteria under 6.1.5.1.
Okay, thank you. And then I guess I have another question. I guess I'm more curious, and because I don't think it's totally within our purview to discuss rights of way, but I'm just curious, how long has this right of way active, the current location of this right of way been used as currently situated?
For more than 15 years.
Okay.
Okay.
Thank you.
Okay.
That's it.
Okay. Those are your questions. Retha. Retha.
Yes. We were there earlier this week. It seems like a fairly small space. And I'm not sure whether it's appropriate or not.
Janet.
Well, I agree with my fellow board members about 6.1.2, the restoration section of the bylaw, but I have something that I'd like someone to clarify for me as regards to the application, which states that this involves two parcels, 154 and 155. I have an old assessor's map, and there definitely were two lots as I see it. Were those lots combined? You gave us assessor cards that show it as separate lots. And when I went onto the assessor's website today, I pulled a card that said that the lots, I guess, were combined for fiscal year 2021, but that's, I believe, for tax purposes. Have these two lots been combined? Am I missing something?
Someone answer that. All right. Unmute yourself. Joe.
Yeah, we did have them combined so that we could build on it.
You went before the planning board and had them combined?
Yes.
And
may I ask you when that was?
We're going to have a 1,500 square foot home built with a little studio apartment also on the side. And so we needed to combine the two together. So we went to the Conservation Committee and I've got it written down. I think it was the planning board.
It would have to be the planning board. So I'm just curious if that was actually done.
Yes. Because we had to in order to build a house.
It might be good if we could see some kind of paperwork on that.
Yes. Right.
I've got a load of paperwork, but I don't know if I can find it right away.
No. All right. Meanwhile, I'm going to go to Andy. Andy, you have to unmute. Yep.
I just unmuted. Hi. Yeah, I have the same problem with the provision that prohibits essentially rebuilding a lot that's been abandoned for more than 2 years. But I'm curious as to what either the attorney or the owner could, how they could respond to the question as to why this wasn't acted upon within the 2 years.
Yes, Madam Joe, go ahead. You have to unmute.
So he would like to know why we did not build within the 2 years?
Yes.
Build or do anything else. Take any action.
Take any action.
So we started right away with looking at plans and talking to, right away, I went to a few builders in Wellfleet to see plans. I've never had to build a house before. And they looked at me like I was an idiot. And they said, you have to find your own plans and then you come to a builder. So that's what we were doing, going on. We went online, we found plans. We have 6 people in our family that we have to have approve it. So we found plans, bought the plans, found out they were from Canada, had to hire somebody from the United States to make them for Massachusetts. Did that, had new plans made, and then we went and had 3 quotes made for the house to be built. And we found out that the price was going to be way more than we could afford. And that was 2 years, 3 years? How many years? It was a couple of years. It took us to between deciding what kind of house we wanted between all of us, and then having the plans made, having to get an architect to do them over again for the United States. And then we found out, I think 3 times we had to go to a United States person to do it. So we had somebody from New York make up the architectural plans. And then we found out that it has to be somebody from Massachusetts. So we went to somebody from Chatham that redid the plans. Then we started with the board of the Conservation Committee, and then we went to the, what is it? Felco did a lot of work for us, but we went through these 2 different plans, and then we found the price after we got the permits approved that we couldn't afford it. That's when we went to having, deciding to sell it. And then we went through 1 realtor, and we were with that person until they closed their business. And then we went to a man in Wellfleet who's helping us right now.
Thank you.
Anything else, Andy?
No.
And I think Mr. Bliss has his hand up. Would you
Yes.
like to speak?
Yes, I would. I'm one of the developers that Mr. Carreno is representing. I have a few points. First of all, as Ms. Fontaine just spoke, they did not do nothing. They went to the Conservation Commission and acquired an order of conditions. They went to the Board of Health and acquired a variance to put in a new septic system. And they had house plans drawn. Unfortunately, for financial reasons, they did not follow through to actually begin construction. The zoning regulations, as Mr. Carreno has spoken to, well, first of all, I spoke to Justin Post before we even made an offer on this property, because I read that same zoning regulation, and he informed me that in his interpretation, that was only applicable if we were going to reestablish the non-conforming use, as i.e. rebuild in kind in the same location, but that he did not read it that way if we were going to build a fully conforming structure that abided by all of his other zoning regulations. So essentially, I saw that bylaw and I asked him if that was a dead end before we got started with this. He also had a conversation, according to him, with Christine about that same matter, because we wouldn't have wasted our time if it was a hard stop, obviously. So that's why we continued, because that was the interpretation that he gave us. A few things from Mr. Thaler. His concern for water quality and quantity is interesting because he has a hose hooked up to his house, which dumps, I don't know how many gallons of this precious water onto his coastal bank replenishment project, which is beach grass, which doesn't require watering. But I'm just wondering if it's so precious, why he doesn't set up a gray water system to water his coastal bank, as opposed to using this water that's no longer in existence to water his plants. As far as his representation that our lot is the smallest on the island, I did some research. There are over 30 lots smaller than our lot. There are over 10 homes larger than what we proposed, including a brand new home that was built within the last 3 years. It's over 4,200 square feet. It's 2,500 square feet. It's not a McMansion by anyone's standards. Its footprint is not larger than his house. It's not larger than the McDonald house. So essentially, we came to the board because of the information that was provided to us by the previous building official, who I understand is no longer here to speak to that. But I have had a relationship with Justin in other towns on other projects, so I know him personally, which is why I approached him. So our view, as stated by our attorney, is that since we are building a conforming structure, the only non-conformity is the size of the lot. And in our view, the fact that we are eliminating the egregious non-conformity of the previous structure, which literally was over one property line and right on the other one. We're doing all the mitigation plantings that were required by conservation. We're trying to be as friendly to the neighborhood as we can. We originally had a bigger house. We have actually downsized the house. So it's a little frustrating for me to be at this point, having invested time and money. When I asked this specific question 6 months ago and was told that it was not a hard and fast rule that we would be considered based on the fact that we were building a conforming structure. So that's all I have to add. And I will wait for the board to, if anyone has any questions, I'm happy to answer them.
Thank you, Mr. Bliss. And I will weigh in on this as well. And I hear your frustration, but I do believe that in this case, the applicable law is the one that says you are required to rebuild within 2 years, as do my fellow board members. I think that the idea is that we would try to get to elimination of non-conforming lots. And so if a lot is left vacant for 4 years, it can return to being a vacant lot rather than having a structure built on it. I think that we have many non-conforming lots in this town that are unbuildable, and none of those people can come to us and ask for a building permit. And I don't think that this board has the authority to give a permit with some kind of twisting of the idea of restoration or reconstruction when we have a clear law that says this is what you do in the event of a structure having been destroyed. And that is my reading of the law. My fellow board members have any further things to say about that? I want to go to the board for a minute, Joe. Will.
Yeah, I mean, I look, in looking at bylaws 6.1.5 about the alterations to non-conforming single or two-family residential structures. I mean, just the title of the section tells you it doesn't apply to this. Mm-hmm. Now, I could be convinced that at least I'd be probably willing to stretch it to say that as long as someone had a right to construct something on the lot, I could see myself being persuaded that 6.1.5 is the section of the bylaw that gives us jurisdiction to look at granting a special permit. But after 4.5 years, this lot has lost its non-conforming status, and it is similar. To my mind, it's just like all the other many small non-buildable lots in Wellfleet. So that's it.
Anyone else from the board?
Sharon, do you think this might be a appropriate question to run by town council?
Yes, I can run it by town council. I have to some extent run it by town council, and I have an opinion that I don't entirely understand. So I can't really speak to that opinion. She says there are situations in which we might be able to to grant this, but they aren't clear to me. But we could certainly, if the applicant wants to continue, we could certainly ask for a second reading on that, if that's what the board wants.
Yeah, I'd like, go ahead, Janet.
If we are going to continue this, I want proof that those lots were joined through the planning board.
Yes.
Right. Okay.
Yes.
And Nick.
Yeah, as I understand it, there was two circumstances. Was when in 2008, the building permits were issued and the governor allowed people an extra 2 years because of the recession. And then also there is an exception for COVID-19, but this does not come under the COVID-19 protocols because this was way before that. And this happened in January. COVID-19, as we all know, came to America in January, February 2020. So it does not, I don't see any way that we can get past that 4 year, even by continuing this and having another hearing. So we're still, to me, the lot is vacant for 4 years, therefore it cannot be built on.
I think the only reason to continue it, Nick, I agree that I don't see any way forward at the moment, but the only reason to continue it, I think, is to seek town council's opinion as to whether or not there is a way to move forward. Okay. Or to validate our opinion that there is no way to move forward. And the other thing I would like to see, if we do continue this, I agree with Jan, we definitely need some kind of proof that this went before the planning board. But I think also the application needs to reference a section of the zoning bylaw that they're applying under, and it doesn't now. They're just asking for, are they even asking for a special permit?
Yes.
But they're not referencing any section. And I think at the very least, they need to tell us what section they're applying under so that we know what section of the bylaw we should be discussing.
Right. And also it seems to me that we're hearing a lot about a lot of other hearings for which we have no paperwork, not just the joining of the lots, but also the other hearings before the Conservation Commission. On the earlier lot, we have the current Conservation Commission, but the fact that, there was supposedly some action on this property earlier, we've never seen, we don't have anything about that.
If I may, the Conservation Commission just approved this last week and the paperwork hasn't been duly sent to DEP as yet.
No, Chris, I'm not talking about that meeting. I'm talking about the earlier meeting that the Mandell family says they went before the Conservation Commission and the Planning Board, and we have no paperwork for either one of those.
I agree.
Yep. Yeah. I don't really see a way forward on this one. I'll be honest. But I am perfectly willing to pursue a continuance and see what town council says is the way forward, if that is the feeling of the board.
Yeah, I think it's fair to all concerned that we check with town council. I agree with you that I'm skeptical, but I've been wrong before.
Okay.
Yeah, I agree with Will and Trevor.
Okay.
It's not going to hurt anybody to get legal advice.
Trevor requested that. Okay, I will listen. I'm sort of going, we're winding this down, but Mr. Mandell, if you would like to speak, go ahead and unmute yourself.
I just wanted to clarify.
Wait, it's Mr. Mandell first.
Sorry.
Sorry.
Yes, my name is Steve Mandell. I'm one of the owners. And I understand from my daughter, Sarah Mandell, talking to Ben Zender several years ago, that this 2-year rule applies only to the original owners. That would be us. Why is this rule being applied to people who want to buy the property and develop it their way? It doesn't seem to be right. It seems like you're trying to make as many vacant
Mr.
lots
Mandell, what that law means is that you are the only ones who have the, you have the 2-year right to rebuild your house, but you can't sell an unbuildable lot that has become unbuildable after 4 years of being vacant. That would be the same as someone else selling an unbuildable lot.
Well, can a variance be applied to make it a buildable lot?
That would have to be applied for. And this board doesn't usually give variances for non-conforming lots, but there's always a first time.
That looks like it's a next step for the developer. Thank you.
Will, you had another.
Oh yeah, I was just commenting that the 2-year rule applies to whether you had one owner in that length of time or you had 100. So it runs with the land, not with the lot owner.
Okay. All right. Anyone
So
else?
I move that we table this until the January meeting.
Okay.
I'll second that.
And it's been moved and second that this hearing be continued to the January meeting so that we can seek town council, but the applicant also has to provide us with a lot of other material between now and then. So the applicant needs to be able to make the January meeting. So that has to be something
we should also give the applicant the applicant should request a continuation, I think.
Right. The applicant has to contest,
impose it, because they could also request a vote or they could request to withdraw.
Right, exactly. So I guess I'm going back to you, Mr. Kiran. What would you like us to do here?
I think for the time being, we would ask that the matter be continued and get an indication what additional information the board is looking for. I didn't see any specific reference in the application looking for a specific bylaw section. I did see a reference to Chapter 40A, Section 9 and Section 6. So maybe I missed that in the application, but be that as it may, I guess I would also suggest that typically that 2-year rule has been intended to protect the ability to recreate a non-conforming structure. And because we're not doing that in this particular case, I would suggest to the board that the fact that the building was taken down does not result in an abandonment of the buildability of the non-conforming lot. But that's something that certainly you can take up with town council and seek some insight from town council in that regard.
Okay. And by the way, for your information, that question about what section of the zoning bylaw is number 4 on the form. It says, make a brief statement of what you are requesting from the board and under what section of the zoning bylaw or mass general laws you are applying. And as you'll see on this application, there's no mention of any of that.
Madam Chairman?
Yes.
Could Chris give them the date of the January meeting and the date when every bit of material has to be into her office?
Yes, that's what I was about to ask. Chris, do you have those dates? They're behind me somewhere. I can sort them out, but
I have them.
It's January 14th.
And when would they have to have paperwork?
January 5th.
January 5th. Okay. All right. So you are requesting a continuance from the board,
That is correct.
and that those dates work out for you, and the paperwork can be in by January 5th?
I believe so.
Okay. All right. So then I'm heading back to Will has made a motion to continue to the January meeting. And I believe Mick seconded it. Yes. Mick, did you second that motion?
Yes.
Okay. So then I need a voice vote. Trevor,
Yes.
Will,
Yes.
Mick,
Yes.
Janet,
Aye.
and myself. Yes. Okay. We will continue to the January 14th meeting. Thank you all.
Thank you.
Okay. A minute for the little boxes to readjust themselves. And while the little boxes readjust themselves, I'll call 2019
I want to thank
Grannis.
you guys and wish you a Merry Christmas.
Oh, Merry Christmas to you, Mr. Taylor. 2019 Grannis, 3075 Baker Avenue, map 20, parcel 61. Application for a special permit under Welfare zoning bylaw 6.1.5.4B to construct second-story living area within the same footprint on a non-conforming lot. Okay. And I believe it is, let me set the board. The board for this is Trevor, Mick, Will, Retha, and myself. And it is, I believe Mr. Morse is going to present.
Yes.
Wherever you are. There you are. Yes.
here.
Mr. Morse,
Thank
you have the floor.
Thank you, Madam Chair, and good evening, everyone. I'll try to be short and sweet here. My name is Dan Morse from Elite Property Services and represent John and Ornella Grannis, the owners of 3075 Baker Ave. We've been hired by the Grannis as a general contractor to perform renovations to their home and seeking permission under bylaw 6.1.5.4B to make modifications and improvements to the home on the existing footprint. We're only modifying the second floor, which is currently a walk-up attic space, to add living space in that area. It'll bring the home from a 2-bedroom, 1-bath to a 3-bedroom, 2.5 bath, and go from approximately 760 square feet to about 1,060 square feet. So add about 300 square feet of living space. Again, we're working on the existing footprint. We're not changing anything as far as the footprint of the property. We have had a Title V inspection and passed that per the Board of Health. And that's where we're at. So I'll open it up to any questions.
Okay, thank you. And we have one letter in support. Dear committee members, our family has lived seasonally directly across the road from the Grannis residence for 25 years. We have reviewed the Grannis renovation plans and fully support the project. It will have no negative effects on the neighborhood and will fit in nicely with existing homes. We therefore urge the board to approve the project and to sign Stephen Bliss and Francine Cohen of 3076 Baker Avenue. Is there anyone in the audience who would like to speak to this application? Seeing no hands, I will go to the board. Trevor.
No comments at the moment.
Okay, all right, Nick.
No comments at the moment.
Will.
No comments.
Okay, Janet.
Yeah, the assessor's well, first of all, the plot plan doesn't, unless I missed it, doesn't tell me what the square footage of this lot is. And I see what the assessor's card is, but they're not always accurate. Can someone tell me what the square footage of the lot is?
Mr. Morse, do you know what the square footage of the lot is?
The certified plot plan I have in front of me is plus or minus 9,600 square feet.
Okay.
That is in our packets, Jan.
Yeah, I thought it was.
I believe it is.
Mm-hmm. Yeah.
The other question is, the assessor's card said this is a 2-bedroom house, and I see this is going to become a 3-bedroom house. So how is that going to happen?
The plans right now, it's a 2-bedroom, 1-bath house with, like I said, a 2nd floor walk-up attic space. So now the 3 bedrooms are going into that 2nd floor living space.
I understand. I'm just trying to understand how you're going to put 3 bedrooms on an undersized lot that's only allowed 2 bedrooms, unless, again, I'm missing something.
I'm not sure how to answer that.
I believe, Janet, that this went before the Board of Health for a title,
Yes,
for an
it did.
upgrade of its septic system.
So
And
they're permitted for theirs, permitted the 3rd bedroom?
they were permitted the
Yes.
3rd bedroom.
And,
Yeah,
and the baths, yes.
yeah. We go by bedrooms here.
Oh, sorry.
But I believe they have been before. I think that,
Okay, as long as-
yeah.
And then could you just, and again, this is, I'm sure me, but I'm looking at the plot plan and it shows me 3 lots. I don't understand that. Lot 131, lot 155, lot 190. Why? I don't understand what's going on there. What exactly are the setbacks? And why does that show 3 lots?
Oh, you know what? Look at a different plot plan.
I'm looking at a certified plot plan.
10/21/20.
Oh, let's see. Yeah.
Yes.
I don't understand that. So could someone clarify that for me? Because I'm trying to understand what the setbacks actually are.
Speak to that, Mr. Morse.
Yeah, I don't know why those lot numbers are there. I mean, it is a single lot. The setbacks, the property lines to the home behind, which is on Buck Street, which is on the west side. I think that setback is over 30 feet. To Buck Street is 46 feet, and then the property to the right of the home, the neighbor, which is on the northeast side, is 43.5 feet.
Okay, so the setbacks that I see here are correct. It's just
They
I
are.
understand why
Yes.
those lots were there. Okay.
Yeah, I don't have the answer to that, but those are the correct setbacks.
Okay.
I think that section of town was originally subdivided into sort of like Lieutenant's Island, subdivided into microscopic little lots, which were many of which were combined into larger lots years and years and years ago.
Yes.
Yeah, there are some lots on Lieutenant Island that were sold in Cracker Jack boxes.
Right.
Yes.
Good, thank you.
So, anything else? Janet, any other questions?
No.
Nope. Andy?
No questions.
Questions. Did I get Risa?
I'm just wondering about the volume. Is there an issue with the volume? Increase?
I mean, there is an increase in volume, but we've routinely given special permits for that over the years.
All right. It doesn't change the footprint.
Doesn't change the footprint, right?
Not
Right.
change the footprint, no.
Okay.
I would note that we only about 2 meetings ago approved the neighbor's property to put a 2nd floor on their entire garage, keeping in the same footprint, which is a very conceptually pretty much exactly the same thing that the applicant is asking for now.
Right.
Okay. I have no problem with that.
Okay. Yes, Janet.
Actually, one more question since we're talking about volume, and this is just for my own education. Is this volume, is it calculated correctly? Isn't the volume of increase just the part that hangs over the setback? Isn't that all the volume? Isn't that how the volumetric increase would be calculated as opposed to the entire addition?
Well, I suppose the only volume that we would be concerned with is the part that's within the setbacks.
Yeah, that's right. Yeah,
I don't think we have to put a number in our findings on the volumetric increase. We can just say that there will be one.
I'm just curious because that's exactly what I thought, Trevor. Thank you.
We have a number in the in the draft findings, but we don't need to have
take
it.
it out and say, yeah.
Yeah.
This is the property that work started on a little prematurely. Is that
Right.
correct?
Yes.
The Wellfleet way, of course.
We got some different advice from the previous commissioner.
Oh yeah, blame the guy that's not here. Yeah, we've heard that before.
Yeah. See, Paul, see what you're up against. All right. Any other questions on this one?
This seems pretty straightforward to me.
Yeah.
Okay. All right. Are we ready?
Did we hear from Mick?
Yep.
Yeah. Mick was first. He had no questions. Nope. So are you ready to go to findings?
I move to go to findings if you have something that you'd like to read to us.
I do. I have something to read. Thanks to Will, I have something to read to. So I need a second. Will, did you second going to findings?
Yes, I did. Yes, I did.
Okay, and I need a vote. Trevor.
Vote to go to findings?
I think we have to vote to go to findings.
Yeah, aye, yes.
Nick?
Aye.
Will?
Aye.
Retha?
Aye.
And myself, aye. Okay. 2019, John and Ornella Granas, landowners, and Dan Morse petitioner, 3075 Baker Avenue, map 20, parcel 61, request for special permit for a second floor addition to an existing non-conforming structure, front setback. The application is for a special permit to allow for an addition to the property, a full second floor over the first floor, which is hereinafter referred to as the addition. Without a special permit, the addition would not be allowed due to the fact that it would result in an enlargement of the building currently within the non-conforming pre-existing setback. The existing nonconformities are front setback 12.8, where 30 is required, and lot size 9,583 square feet, where 30,000 square feet is required. The addition would be constructed on the existing footprint of the structure and would increase the square footage of the structure and the volume. The lot is in the R1 district. There was one letter in support of the application. There were no letters or appearances opposed to the application. The applicable provisions for this application under the Town of Wellfleet zoning bylaws are section 6.1.5.1b and section 8.4.2. Section 8.4.2.1, the board finds that the addition is suitable in that it is compatible with nearby land uses, which would not be damaged by the addition. The board finds that the roads, drainage, and other public utilities would not be affected by the addition. The board finds that the addition will not contribute to environmental damage. Section 8.4.2.2 is not applicable, and section 8.4.2.3, the board finds that the building and site design will not adversely affect scenic views from public ways or neighboring properties. Therefore, the board finds that the addition will not be substantially more detrimental to the town than the existing non-conforming structure. That's what I got. Changes, questions?
I move we approve the findings.
Okay, I need a second.
I'll second that.
Okay, and again, a vote. Trevor?
Yes.
Nick?
Yes.
Will?
Yes.
Retha?
Yes.
And myself, yes. And having accepted the findings, I need a motion to grant the special permit.
I'll make a motion to grant the special permit.
I'll second it.
Will seconds, and I need a vote. Trevor?
Yes.
Nick?
Yep.
Will?
Yes.
Retha?
Yes.
And Sharon, yes. Okay, Mr. Morse, you're done. Chris, can you fill him in on next steps?
Yes. I will get the decision typed up and get it signed by Sharon. Get it filed with the town clerk, and then there is a 20-day appeal process, at which time, after she signs that there's no appeal, then I will send out the appropriate paperwork to you so you can take it to the Registry of Deeds.
Great. Thank you.
Okay. Thank you very much.
Thanks so much.
Okay. So Mick, you have recused yourself from this next case, so you get to leave unless you want to leave and come back.
No, I'll probably, but before you call the next case.
Yes.
It's time for me to step down from the zoning board. I've been on the board for a long time.
No,
and-
no, no, no.
Oh, no, 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 no.
There you go. So I've been on it for a long time, and my heart isn't in it anymore since we lost Bruce. I don't know, I'm really bummed out about that. And I just need to step away from the board. So, but I will stay on the board until we find another suitable person to join the board. But it's time for me to go down the road, happy trails and all that good stuff. So.
Of course, you've given us the out now that we just won't find another person, and
Well,
you'll have to
we don't.
stay.
I will stay around definitely because I've been on that the first hearing that we had tonight, so I'll stay around for that.
Okay, very good.
But if we can find some suitable applicant, it's time for me to just move on. And I've had a good time on the board. I've learned a lot. I've learned especially the fact that a lot of times I'm not right, and that's the beauty of being on the board, to acknowledge that. But it is time for me to move on. So I want to thank you all for that, and go to the next hearing.
Well, thank you, Mick, and I'm hoping you will still be on the board when we have another meeting in the actual senior center where we can actually see people.
Yeah, that's the other
and
reason.
hug you goodbye.
I can't do the Zoom meetings anymore to do my head in. So. All righty.
All righty. Okay.
Good night, Mick.
Take care. Good night.
Talk to
Good
you
night,
later.
Mick.
Good night, Mick.
Okay. All right, I'm going to call this meeting 2007 Starboard Tack Holdings Incorporated, Maya Beck Baum and Thor Baum, 30 Ryder Court, map 14, parcel 19, of application for a special permit pursuant to Massachusetts General Law 40A, Section 6, and Wellfleet Zoning Bylaw 5.3.2.6 and 6.1 and 8.4.2 to alter a pre-existing non-conforming property in the commercial zoning district by demolishing the existing two-story residential use building and constructing a two-story mixed-use building with commercial uses on the basement and first floors and two residential apartments on the second floor. And this has been continued for a very long time. I'm going to set the board. The board remains Trevor, Will, Janet, Retha, and Andy. I am not a voting member of this board, but I am chairing the hearing. And I'm going to take the Roger prerogative as chair and make a few observations before we start. And in beginning these observations, I have to apologize to Janet, who needs to have more of the courage of her convictions and fight us harder.
Okay.
This application appears to me to be fatally flawed. Even before we learned of the illegal expansions to and use of the garage on the property last month, we had a number of issues with parking and intensity of use and the use of the Ryder Court and so forth. However, I have been advised by town council that we have to deny this application because it asks for multiple uses on a lot in the central district, and we are not allowed to grant a permit for multiple uses in the central district, which is what Janet has been saying all along, and she is correct. So we can, if the board and the applicant, and I know many of you have come here to speak on this project, if you would like to go through this application, we can hear all the letters, we can hear from the abutters. The letters, we have many letters for, we have many letters against. We can consider the parking, but the problem is we cannot grant multiple uses on this lot. So I leave it to the board, and I'll play ping pong here and I'll leave it to the board as to how much you want to bend on this. But right now, the application we have in front of us is not possible to approve.
And to be clear, that's an opinion that you got from our town council.
From a 1-hour conversation with town council on Tuesday.
So, Madam Chair, I am concerned about that provision as well.
Mhm.
And you can hear me, right?
Yes, yes,
Yes.
thank you, Andy.
But I'd like to hear from the applicant's counsel as to what his position is on that particular bylaw and this situation.
Sure. Mhm.
So if the rest of you don't mind, we could ask Ben to respond to that.
Certainly, certainly. Are you agreeable with that, board?
Oh, I absolutely agree with Andy that we shouldn't just plow forward without letting Ben
Right,
speak.
right.
Yeah.
Right. So.
Well, are you sure you guys don't want to give me 45 seconds to prepare for this question as opposed to 30? I think I'd like, obviously I want some time to look into this because, the bylaw says that more than one allowed principal use and or principal building may be permitted on a lot in District C and District C2 with a special permit. It doesn't say that you can't have one somewhere else. And trust me, we'll be doing the research this week, but I'm willing to bet that there are numerous multiple principal uses or principal buildings on lots that are in either the residential or the R2 or the central district or any of the other districts that aren't C and C2 in the town. And so I think if the board's going to deny this on that basis, I think we're going to have a problem. I would at least like to have the opportunity to research the history of this particular situation in the town before the board turns this down. I'm at a loss. I mean, I would like to have known about this issue a little earlier so that I could prepare for it.
Sure.
But Ben, can I just interrupt?
Yeah.
I believe you received the letter from Attorney Reed, and he raised that issue.
Yeah.
So I mean, I'm not saying you shouldn't. Well, if you want some time, by all means. I'd personally be glad to give it to you. I'm just saying, I don't think it's not totally fair to say that,
okay, but look, does that mean that you can't have affordable accessory dwellings in the central district or in the residential district, or you can't have an additional use in one of those? It just doesn't seem to make any sense. I think
affordable accessory are specifically called out because otherwise they would not be allowed.
Right.
Yeah. Well, no, they wouldn't be allowed because they're multiple dwellings on one lot, not because they're multiple principal uses on one lot. So
actually, this one only is allowed multiple uses on the lot because of the 1983 special permit, which is grandfathered. But right now, if you want to create a multiple family dwelling in the central district, it's not allowed.
Right. No, I understand that. So, I'm at a loss right now on this. Yep. I mean, I think we're going to have to ask for a continuance to address this legal question. I'd like to, I would like to ask the board to allow the chair to share that opinion with me so that I can review it with my client. Sure. And then we'll address this legal issue for the board. But I think we want the quickest continuance we can get, which is obviously your next meeting. So.
And do you want us to go through the other problems with this application?
Yeah,
I mean, we can do that if you'd like, but I mean, it's not, that one is the showstopper for me, but I know that this is that things like the parking and the use of Ryder Court are all issues that are of grave concern in this project. So it's not, although this is a problem, even if we solve this problem, it's not the only problem, which is why I think and I am not a lawyer and I am not supposed to be giving you advice, but I really think your clients need to rethink the project rather than simply researching the law.
Well, obviously I think we have a right to do both. So first of all, I don't think tonight should be wasted. I was prepared to educate the board as to the steps my clients had taken to address the concerns the board had at the last hearing. And if I may, well, first of all, I thought that, Will especially had some requests that were legitimate requests. He asked for an updated narrative to explain the project, and we did that. My clients have, and Thor has removed those 2 sections of the garage that were built without permits. He obtained demo permits to do that. He removed those, which was quite a bit of work. What we're going to propose, and I think the concern on, at least on behalf of some of the people that addressed the board, was that there's too much going on the lot. And I think that those were legitimate concerns. And so, immediately Thor and Maya began looking for another location for his business, which you all know is difficult for any tradesman to find a place to operate out other than their own homes in Wellfleet. I had suggested the narrative that he remove himself within a year. What I was going to suggest actually is that the board, if it saw fit to grant a permit, conditioned it so that there'd be no commercial operation of that garage. And it all be ceased prior to the issuance of any CO for the occupancy of that building, which means that nobody in town is going to be faced with the prospect of multiple commercial uses on the lot. We reduced the parking in the main lot down to 5 spaces because of the request of one of the abutters. I think we made a good argument under your bylaw as to why this board was authorized under 6.1.3 to form its own determination of the appropriate amount of parking. The location of the building in the center of town lends itself to reduced parking on site. And we conveyed to the board at the last hearing that we felt that the only necessary parking on site was parking for the residents of the 3 apartments and handicap spot and 2 spaces for employees, which we think would work very well. We removed the parking on Briar Lane. So we have obviated the concerns of both the fire department, DPW and police as to backing and turning onto Briar Lane. And, given the location of this building in the central district, it's, we believe it's an appropriate use for a young couple to engage in. So obviously the legal issue has to be addressed. The applicant could remove the apartment use and get rid of 3 valuable apartments in the center of town and present this to the board. Or not have this business for Maya in the center of town in the buildings they own. So we'll address the issue. We'll research the issue. We'll be prepared to go forward on the issue. But I believe that the applicant has, in strong good faith, addressed the concerns that members of the board had about the use of this property. I really believed and felt that we were in a position to present a project that is good for this town. We will address the concern that you have and address the legal issue, but I'm just not prepared to offer a solution to that tonight on this notice. So thank you.
Okay, so I'm going to hear from the board rather than the abutters for now. I mean, I know that there are lots of people here who would like to speak to it, but given the strangeness of this hearing, I think it would be better if we let the board speak rather than that. Does that make sense to people?
No, Sharon's will. I prefer to hear from the audience again, because I see Denny O'Connell's on the screen, and he was the head of the parking committee that I was a member of, and perhaps he'd like to weigh in. So I myself would like to hear again from those in the audience that want to have a say.
Okay. Do you also want me to read all of the letters, or go to the audience first and then read any letters that haven't been?
I don't care about that. Whatever you decide is fine with me.
Andy?
Yeah, I mean, I want to be fair to the applicants, but by the same token, we've got a legal issue that perhaps may be insurmountable. We're going to give the Attorney Zender the opportunity to respond to it, and well, he should have it. So I'm just sort of confused as to how much time we should devote. I think there are some issues we ought to discuss tonight. I would like to discuss, one of which is parking.
Okay.
But I don't know. I guess I could go either way, Will. If you want to hear from the audience, that's fine. That's fine.
Trevor?
Yeah, I don't know. I think we can hear I think it's only fair to hear from the audience, I suppose.
I wasn't saying that they shouldn't ever be
Right.
denied.
Right. No, I know, but
You understand what I'm saying, Trevor.
yes,
Okay,
yes.
that's fine.
All right. Shall we take them in chunks?
Jan's got her hand up.
Chairman,
Yes.
I actually agree with what the method that you originally started with, is that you'd hear from everybody on the board first. Maybe it was or wasn't worth, I don't want to say it's not worth hearing from the audience. We obviously do, but I personally like to hear how the board feels about this application based on what you said and based on other things that we've discussed.
Sure.
But
okay, so who have we not heard from? Retha.
I think this project has a lot of problems, and that it affects the neighbors pretty seriously. And we need to have it explored further.
All right, so who have I not heard from on the board? Trevor? Anything else?
Yeah, I mean, if this is, I think the issue of whether or not this is even doable in this district, I think is, I mean, like you said, it's potentially a showstopper. We have an opinion from. Can you maybe, Sharon, maybe you can tell us a little more about your conversation with town council? Did they provide us with anything in writing, or was
I
this
don't. This was mainly conversation. I can have her write us up an opinion. She didn't. What she said was,
And
if
I
I
think
were,
that would be very helpful if we had some kind of opinion from town
I will
council
ask her to write it up.
We can all
but,
see.
Yeah. But basically, her feeling was there was too much going on that this district does not allow multiple uses, and that this proposal is, in her words, a mess. And that's what she would have told Ben, that this is a mess and it needs to be rethought. And that's
Madam Chair, Sharon.
Yes.
I have to object to that. I mean, like, town council's there to advise on legal issues.
Yes, she is.
The propriety of a project, and so I think it's a little inappropriate for her to even say that, let alone have it.
Okay, I maybe shouldn't. It's probably my fault, but that I shouldn't have said such a thing. But basically, her reading of the bylaw was that we don't allow multiple uses in two districts, and having not allowed them in other districts means they're not allowed there. That's the reading.
Thank you.
And I will get her to put that in writing.
Madam Chairman, could I make a few comments? Okay. Attorney Reed in his letter pointed out something that, my bad, I didn't notice initially. And he points out that the proposed building creates a new nonconformity at the rear setback on Ryder Court. And as a board, we're not in the business of creating new nonconformities. So I want to point that out. Also, the DEP, and again, we don't control septics, but DEP, when they granted a new septic in '94, said there should be no future increase in sewage flow, which to me, it seems this project would, and no increase in the square footage of the existing structure. How could we grant a permit for something that DEP said they can't do? Maybe we can, I don't know. I have a hard time getting past that no parking can be provided for patrons. I can't get past that. And I'm not happy with, I think we're down to 22% proposed coverage, where 15 is allowed, and there's 17, I think now. I think that's a lot. I'm also curious, and I don't know the answer to this either. Attorney Reed said that an abutter, Lewis, did not receive an initial notice of these hearings, and she's now aware of them. That concerns me. I don't know if something went awry with notifications of abutters, or it's just overlooked or lost in the mail. I don't know, but that certainly concerns me. Okay, I'm done.
Okay.
If I could respond to the notification, I will take time to look up to see if she was on the abutters list.
Okay.
And if a letter was sent.
Okay.
And you have to remember, the initial hearing is the only notification that they get. And this was notified way, way back.
Okay.
Last
Yeah,
spring.
The initial hearing on this was actually in April, and there was no hearing because that was the Zoom meeting that in fact did not happen when everything was going to be continued. So yeah, there have been some screwy things.
Thank you.
All right. Anyone on the board who has not spoken want to speak before I go to the audience?
Yes,
I do have some comments, but I'd like to defer them until I hear from the audience.
Sure. Okay. Anyone?
Madam Chair.
Yes.
I just want to clarify on what we got from Ben this time says that there will be the second proposed, the second floor would be divided into two-bedroom apartments. And he just said 3 apartments.
One's in the cottage.
Is that the cottage too?
Yeah.
That- The cottage?
That's the third.
Third one's in the cottage.
Oh, okay.
Okay. All right. All right. So
Madam Chair, you'll come back to us after you heard from the audience?
yes, I will.
Okay.
Yes. Okay. So now I'm open to the audience. If you would raise your hand, Mr. O'Connell.
Greetings all. I wasn't aware of all the intricate issues of this project, but a couple people have mentioned to me about the parking, and when I started to do a little research on that, I was surprised to see the reliance on public parking, which is not a common thing, and frankly is something that the parking task force talked about when we were in session. This is me speaking. It's not the parking task force, but in reviewing our notes and our work, one of the issues that came up was the expansion of business without the provision of parking. We know that Wellfleet, or I believe that Wellfleet is certainly over desirable for parking in the summertime, and already we have a shortage. This would add to the public parking shortage, and I would be very concerned about trying to allow that without allow an increase in business without providing for parking. I know that there have been other projects that have gone through where no parking has been provided, especially in the central district. But I think that's something that you need to carefully consider. I guess I'd also ask, have you determined that this is development of significant impact?
Yes, we have considered this to be a development of significant impact, and we referred it to the planning board in June. The planning board has not met, and therefore the planning board did not act on it. The planning board finally did have a Zoom meeting, I believe in October, but at that point they did not take up this project. So we have only to conclude that they have no opinion on it.
I understand your position. So I guess I would discourage this project from consuming more public parking. Granted, it's not a big issue at this time of year, but come summertime and actually most of the rest of the year, it's not right. So I would hope that there'd be some way that the applicant could provide parking in order for this project to proceed.
Thank you. Okay. All right. All right. From the audience. Mr. Reed, would you like to speak? Yes.
Thank you, Madam Chair and members of the board. I really don't have anything to add to my letter, and I'm pleased that you've all had the opportunity to receive it and read it. And obviously you have and given it fair consideration. I appreciate that very much. I do happen to agree with town council that the provisions of section 5.4.13 are prohibitive of this requested relief. I think it's plain on its face that allowing a particular category use only in certain districts by necessary implication prohibits it in other districts. So I think town council is absolutely correct, and this just can't be accomplished in the way it's proposed. I don't feel the need to address all the other concerns that I raised in my letter tonight, because I think you're obviously going to have another crack at this, and Mr. Zenda may have some other changes to make in his proposal or some other suggestions at that time. So with your permission, I'll reserve the opportunity to address you again at the next meeting if that appears to be appropriate.
Certainly.
Thank you.
Thank you. Okay. Anyone else? Not seeing any hands. I don't know if. Yeah, does the board have any other things to say?
Yes, I would like to talk about parking just a little bit. Ben, I'm confused about, first of all, how many spaces you're now proposing. And then after you tell us that, tell us why you believe that there's, I don't want to say any conforming relationship, but we have the parking regulations in the zoning bylaws, and I'm not really sure what type of use this is. As applies to that zoning bylaw, but I'd like to hear from you, both really to the factual and the legal issue, if you wouldn't mind, about parking.
Okay, if you through the chair. First of all, in the zoning code itself, I think the use this most closely approximated is what's called a personal service use, and that is in the use table as a permitted use by special permit in the central district. Your parking provisions set forth certain requirements for parking for different uses, but then it has a general provision in 6.3.13a, which says that other uses not mentioned, specifically mentioned in the code, in the parking code, the parking requirements are set by the zoning board of appeals if it involves the grant of a special permit. So my reading of the zoning bylaw is that this board is authorized to determine the appropriate amount of parking for a use because it's a use that's not specifically mentioned in 6.3.13 as to the required parking. That's the legal.
Okay.
As to the factual, as the board knows, there are many businesses in the center of Wellfleet in this immediate vicinity that don't have parking. The Lighthouse Restaurant, for many, many years, having, well over 60 seats, no parking. The businesses along Main Street, many of them, even if they have some parking, Cape Cod 5, for example, have some parking for employees, have no parking on the street or other off-street parking for the people that use this. We believe that this particular use, which is a year-round use, unlike most of the businesses in the center of town, is a use that people could park at a number of public lots, which are available to the public for use for whatever purposes they want, whether it's the town hall, the Catholic church, the library, the Main Street, the parking along Main Street on the street. Those are all streets that are available to the citizens and non-citizens to park and use. And this property is within easy walking distance of all those lots. And we also think that people that will use this facility may well ride bicycles to the property. They'll walk to the property from their homes if they're in the center of town. So we don't think that having a small amount of on-site parking is going to create either a parking problem on this site, or given the the volume of the use of Wellfleet at certain times of the year and how desolate it is at other times of the year, is going to in any way meaningfully change or shape the way that parking is utilized or viewed in the town of Wellfleet. We don't think that this particular business is going to have any effect at all on that. with regard to the development of significant impact, I think as we talked about last time, or as I talked about last time, this board has the authority to require a traffic study. But a traffic study is going to inform you based on national studies, what the average amount of traffic is going to be for a facility of this particular square footage. They could do traffic counts along the roadways, and they'll tell you what those traffic counts are. But I think that this board is probably better able to evaluate, the traffic impacts of this project than a traffic study, which would cost the applicant more money and cost more time. So, the amount of parking that's been provided on site is based upon your zoning code requires or provides for 1.5 spaces for an apartment. And so we rounded up at 3 apartments to 5 spaces that are provided. And we've provided extra spaces for both handicapped and employees. We thought that it would be good for the immediate neighborhood not to have parking for patrons of this property on site, because it would mean that they wouldn't try to come in and park or scrabble for the available spaces. So in that same vein, we reduced the parking in the primary lot, at the intersection of Briar Lane and Main Street to 5 spaces. And that was something that was suggested by one of the abutters. So we could certainly show more spaces in that area, but we thought it would be advisable to have a condition that patrons of this business, other than a handicapped user and other than the employees, not use the on-site area for parking. So we think parking is appropriate. We think it's available. And we think that this board has the authority to determine what the appropriate amount of parking is. So I understand that the Parking and Traffic Study Committee, as Denny said, has a concern about intensifying uses in town. But by the same token, you want your citizens to be able to survive in this town, and that's what this project is all about. So, and I'm wandering a little bit. That's the answer to my question, Mr. Freeman or Andy.
May I just ask for clarification from Ben?
Certainly.
I'm not sure. Could you just tell me what section was it that you were talking about before?
Are you talking about the parking provisions, Andy?
Yes.
Yeah, it's 6.3.13, and it's on page 31 of my code. I'm not sure, if the pagination is the same.
Yeah, it doesn't. That's definitely not on mine.
Okay, it's 6.3.13A, and I'll read it for the board. It's not very long.
Mm-hmm.
It says other uses. Parking requirements for all other uses not specifically mentioned shall be determined by the Board of Appeals for those uses controlled by special permit, and by the Board of Selectmen or the Inspector of Buildings appointed by the board for those allowed uses unless such use is subject to provisions of 6.3.13 of this bylaw. And when the board looks at 6.3, 6.3, there's a whole list of the different types of uses, that have allocated a number of parking spaces: retail business, banks and similar business, motels, inns, funeral homes, restaurants, residential areas, non-residential uses. It says in all of the cases of non-residential uses in residential areas, we're not in a residential area, we're in a central district, and then industrial, manufacturing, wholesale. It goes on to the number of things. So, I believe that this use falls under the under uses category, in which this board can actually make its own determination as to what's appropriate for parking.
And one more thing, Ben. I'm sorry, I didn't mean to interrupt.
No, it's my job.
What use did you say you thought it was most aligned?
Yeah. Looking in the use tables, I believe this falls under what's called a personal service use, and that's defined in the definition section. And I'll read it very quickly. It's very short. Let's see if I can find it here really quickly. Hold on.
That's okay. You don't need to find it.
I put page numbers in my notes just so I can find things again. So bear with me 1 second.
It's like I'm frozen.
Yeah. It's called business personal service. It's any building or part thereof used for the purpose of rendering a service upon the premise to the public, where the sale of a product is not involved. And so in this case, what Maya is doing is she's offering the service of training people, giving classes, providing that service to them. The juice bar, I think the juice bar, is a small part of that. That might raise somewhat of a separate question whether that's a personal service business, but I think that's ancillary to the use. But I believe this falls under the business personal service category, which is allowed by special permit in the central district.
Okay. Thank you.
Madam Chairman?
Yes, Ann.
Just as a bit of a rebuttal or additional information, Ben cited a number of businesses that don't have parking, but on Main Street, those businesses are covered under the Main Street Overlay District. And in the Main Street Overlay District, the Board of Appeals has the ability to reduce or even waive parking. So they're covered under a separate bylaw. And, you know,
Madam Chair, may I ask a question as well?
Yes, you may. Will.
This is a question for both Ben and Attorney Reed. But I noticed in paragraph 6.3, it says that off-street parking shall be provided with the following minimum standards.
Yeah.
And then I look over at 6.3.7 entitled non-residential uses. And it says in all other cases of non-residential uses in a residential area, there shall be provided at least one space for each 3 employees, plus one space for 150 square feet of gross floor area.
Right.
So why isn't that exactly where we're at? And that the required, the minimum is 150. Now maybe a square feet per. It is 3,755 square feet. If my calculator is correct, that's 25 spaces.
That's exactly what I'm. Yeah,
maybe I'm wrong, but.
Well, I came to the same conclusion, Will, but I'm assuming that the applicant is asking for a waiver.
No, we're not, because that has to do with parking in a residential area. This is a central district. It's not a residential district.
Actually, I asked for clarification on that, and town council's position was that residential area and residential district were not the same, and that this is a residential area by virtue of the surrounding area.
And Sharon, Attorney Reed has his hand up.
Yes, Attorney Reed. Sorry.
Yes, thank you, ma'am. I believe the question was to both of us, and if you look at the site plan that the applicant has presented, that is precisely the calculation that they used to determine the parking demand, not the parking that they wanted to provide. But that appears to be the precise calculation of 150 square feet per space that they used to determine that 19 spaces were required.
Even then, my math comes up with 25 just for the commercial space. Never mind the 3 residential units.
You may be correct. I did not double check the math. I'm just saying that that's the methodology that they used.
Right. Thank you.
Yeah, that was my question.
Yeah, I mean, I just like to say that overall, I would like to see this happen. For a number of reasons, but I am concerned about a number of our zoning bylaw provisions, and at this point, I don't quite know what to do. But particularly, of course, the perhaps fatal one, the multiple uses. But like I said, I'm certainly willing to allow the applicant and their attorney to provide a response.
Is there anyone else from either the board or the audience who would like to speak to this? Brad, would you like to speak?
Please, yes.
Yes.
I just have a question. I'd sort of like to ask the board through you, Madam Chair.
Sure.
When they made the decision across.
I can't hear him.
I think we lost you for a minute, Brad. Yeah. The joys of Brad, are you still there? Well, perhaps I'll go to someone else and there are any other hands up. No. All right. Is there anyone else while we wait for Brad to?
Well, I've got a general observation.
Okay.
Just looking, I mean, the applicants are really good folks. Everyone agrees. And I think this is a great business. And I'd love to support it. I'd like to join it. But not at this location. It's just, you know, I did the math, and there's 206 feet of frontage on Briar Lane, and there's 204 feet of frontage on Ryder Court. And because the town has said you can't have any curb cuts on Briar Lane, which is understandable, it puts all of the burden on Ryder Court. And Ryder Court's a dirt road, you know, whatever, you know, 2 cars can hardly pass on it. And then you look at the lot itself is well undersized. And I believe, at least my reading of the statute, the ordinance or the bylaws pointed out by Attorney Reed, would say if someone wanted a 3 residential units today, they would need 36,000 square feet, and this is just south of 12,000 feet. And I just think it's when you combine that, and then with the general understanding that when we look at these, the benefit to the public and the neighborhood have to be greater than the detriment. And matter of fact, 8.4.2.1a says our nearby land uses supported or damaged by the proposal. Well, common sense would tell me that if I'm basically in a residential zone and someone wants to put up a 3,755 square foot commercial structure, I wouldn't be happy with it. It would certainly damage my house if I were there. And then the section below it, 8.4.2.1, it talks about the adequacy of the road. Specific question that we as a board would have to determine: is Ryder Court adequate for this size business operation? And then 8.4.2.2 asked about the intensity of the seasonal uses, including peak period congestion. And Denny Ryan addressed that issue. And in fact, Attorney Reed provided us with a ruling where the 3-unit structure was allowed, or the 3 units were allowed in 1983. And when they granted that permit, I'm reading from the minutes. The plans presented show that there will be no infringement on the property of abutters, and that adequate parking is provided. So that was an issue 37 years ago. You know, so as I say, I think it's a wonderful proposal, but not here.
Yeah. Okay. Brad, you made it back on and you were interrupted in mid-sentence.
I apologize, Madam Chair. My tablet ran out of battery.
Okay.
So I'm now on my phone.
All right.
My question to the board being that there was a decision 2 years ago with the property across the street at Sick Days in terms of this very question about parking. And I wonder if the board could just sort of revisit that for a second and see if they can recollect what their determination was in terms of making Olaf have to provide for the parking that he needed to provide. And of course, I don't know that all members who are now present were on the board 2 years ago. I know Bruce was the one who was sort of I think he was the chair at the time, or co-chair.
He was the co-chair, and Roger would have been chair. I do remember this hearing in the sense that, yes, we did require Olaf to provide the parking in the back. And we also required that he not use the front for parking because of the danger on the Briar Lane intersection there. So
well, interesting. There's a handicap parking sign right.
Yeah, that was the only space allowed on the front was the handicap parking, because it wasn't feasible to get the handicap parking into the building from the back.
I'm not sure it's really appropriate for us to discuss another.
Right, you're probably right, but that is that was that case. I know.
Yeah, that was just a question about that, because I was interested in that.
Right, parking was provided. I believe Mr. Richardson had his hand up a while back. I don't know where he's gone to.
Oh, well, I'll get off for Phil if he wants. But I did have one other comment that I just sort of need to make. And this has to do with my whole feeling about historic preservation, and that I'm the current president of the Historical Society. And I'm speaking for myself. I'm not speaking for the Historical Society. But I really do think we need to look at these buildings downtown in terms of their historic value. They may have problems. They may have issues that need to be addressed with. I live in a building that was built in 1845. I understand it. I appreciate it. But I think when you buy an older building, you have a certain responsibility, and you have a responsibility of the town that you maintain that, because if we start ripping these places down, what are we going to have? Route 28 in Yarmouth? It's like, that's not what we want. That's not what Wellfleet's about. But as I say, I'm speaking for myself. I'm not speaking for the board. But that, I think, is a consideration that needs to be made. I know the Historical Commission has made their decision about that. And we just hope that since it'll be resolved in such a way that we can be able to preserve these structures. And with that, I'll sign off. Thank you.
Thank you. Okay. And Mr. Richardson, you had your hand up.
Yes. My only comment was pretty much what Brad said about Olaf's across the street. It's pretty much the same situation. And it was Bruce in that hearing that said the board had to use the appropriate parking, which I believe is 150 square feet. And that because I think Ben was Olaf's lawyer at the time, and that Olaf wasn't in the central district parking overlay. So it's pretty much what Brad said, is that on that hearing, the board, which I think was Bruce, Manny, I'm not exactly sure who all the other people, Will might have sat on that final.
No, I didn't.
Okay. That the board really had to deal with 150 square foot parking per. That's all I have to say.
Thank you. Okay. Now, I don't see any other hands. Well, actually, I see Will's hand still up, but.
Oh, no, that's my mistake.
I think it's down now.
It's down now.
All right. We do have a number of letters for and against, if you want to hear them.
I think we should. Part of the record.
Mm-hmm.
I mean, we'll waive the reading, Madam Chair, but I understand there's well over 20 letters.
Yeah, there are. Well, but I can give you a number. We have 1, 2, I can't even give you a number. We have many letters. We also have a number of letters for, these are largely not abutters. They are largely people who want to support the business, which is certainly, I think the board does as well. And are in general clients of the business who would hope that we would allow it to go forward. That's, I can circulate all those letters. I didn't, most of them came in at the very end and I didn't have a chance, nor did Chris, to
Yeah,
forward.
could Chris provide copies of those to us? Email them to us? Or?
Sure, or I can.
I will send them all out next week.
Okay, thank you,
Thank
Chris.
you.
Thank you. Okay. All right.
Madam Chairwoman?
Yes.
I would have two requests for the board. One is that they authorize you to share the town council's opinion would be as and when it's available.
Sure. Okay.
And B, that we have a short continuance on this. We're not sure what we're going to do with this. I'll have to talk to my clients. So, with regard to historic preservation, I'm not sure what this board does has a whole lot to do with that, but the inability to use the property will certainly factor into what happens on the property. But I think that's for another day and maybe another board. So,
right. Yeah, we don't have jurisdiction over that, nor do we have jurisdiction over any of the septic issues that were brought up by some of the letters. So.
Madam Chair, I just one more quick one asking you, is there a written
I will have to
opinion?
ask her to give me a written one. I have some some emails, but I didn't ask for a written answer from her. And I see someone named Bob has his hand up.
Hi, my name is Vita Pomprion and I live at 25 Ryder Court. I am in a butter and I would appreciate it if the abutters letters were read because we're actually the ones that are being impacted.
Okay. All right. Bear with me while I find. Does anybody have a? Well, you've heard from Brad, and I have a letter from Brad and Dan, which basically says what Brad and Dan have said. So I think we can probably not deal with that one, but I have two other abutters letters. Would that work to hear those two?
I believe so. Thank you.
Well, Madam Chairwoman, if
Yes.
the board's going to read letters, I would ask the board to read all the letters.
Yeah, that's the trouble. We're going to have to
I don't
read.
think it's appropriate for the board to read selected letters for this.
No,
publicly.
I agree with you. I agree with you.
And again, this hearing is costing my client a lot of money.
Yes.
And I would venture to guess that reading those letters is going to take the better part of 30 or 40 minutes.
Yes, I think so too. Ms. Pomprion, would it be all right with you if rather than reading the letter, if you just said a little bit about what you had to say?
I would prefer that the letter be read because I sat down and really put thought into it.
Yeah.
So if the board would do that, I would appreciate it because we're the ones being impacted. I understand that they have people who attend the gym that want it to go, but we're the ones that are directly being affected as the abutter.
But as Attorney Zender says, I cannot read selected letters. So
well, then
I
could you
either
read
have
them
to go.
all?
What I was going to do was circulate all the letters to the board. I think the board, in fact, has read all the letters, but all the abutters letters, because I think those have already been circulated. I don't know, I need a sense from someone else here on the board. Give me.
I was going to suggest that we circulate the letters and then table the idea of actually verbally reading all of the letters until the next meeting, because pending the opinion from town council, it could be that the continuation is a short hearing.
Yes, that's my sense as well. That, I mean, this has been a long drawn out process for the applicant and an expensive one, and adding to it when we're not going to make a decision tonight seems unfair.
Plus, I'm hungry.
You should have known better than to
I
not
should have
eat
thought
before.
about that in advance. Yeah, that's not your fault. I'm sorry,
No,
everybody.
that's not. I won't, but I won't take that one on. Yeah.
We would ask for continuance to the 14th of
Okay.
January.
Mm-hmm. All right. I'm not even on
Prepared
this.
to move that.
Okay. And we need a second for
I'll
that.
second. I'll second that.
All right. And all in favor? I have to read the board. Will?
Right.
Yes.
Retha?
Yes.
Trevor?
Yes.
Janet?
Yes.
And Andy?
Yes.
Thank you.
Madam Chair,
Yes.
not substantively, but if you do receive a letter from town council, might that be shared with me as well?
Yes.
I'm sure
Certainly.
Mr. Zender will want to see it.
Right. Right.
Thank you.
I will.
Thank you all. Merry Christmas to everybody as well.
Thank
too,
you.
Ben.
Thank
Good
you.
night.
Good night. Good night. Chris, does this board have minutes it needs to act on?
Yes, we have October and November.
All right. All right. I need a
Thank you. We just wanted to say thank you and Merry
Okay.
Christmas. Happy holidays.
happy
guys.
holidays to you. Bye-bye.
You too.
Yep. Yes. Okay, I need a motion on the minutes.
So moved.
The second.
Second.
I'll second.
All right. All
Andy.
in favor. Trevor,
Aye.
Andy,
Aye.
Janet,
Aye.
Retha,
Aye.
and Will,
Aye.
and myself, aye. One can vote on minutes even when one was not at a meeting. One cannot move or second them, but one can vote on them. Curious part of Robert's Rules of Order.
Okay, can I move that we adjourn?
Please.
Then I move we adjourn.
Well, I wasn't at the last meeting, but I'll second that.
You were at the last meeting.
I'm kidding. I'm kidding. I'm kidding.
I was not. I can't second.
I'm joking.
All in favor? Janet,
Aye.
Retha,
Aye.
Andy,
Aye.
Trevor,
Aye.
Will,
Aye.
and myself, aye. Okay, we are adjourned.
All right. Thank you.
All right, thanks all. I will.
Yep.
I will get those letters out to town council and get those opinions.
Okay, great.
All
Thank you. Thank you.
Yeah.
All
Yeah,
right.
bye-bye.
Thank
Good
you.
night.
Bye bye.
Aye.
Chris,
Yes, dear.
what was I going to ask you? So we've just got one to sign, and the others are to are continued.
Yes.
Yep.
Yeah.
Okay. All right. Yes. and we
Yeah.
can turn off the recording and go home.
All righty.
All righty. Goodbye,
gotta-
everybody.
Bye. I'm going to end it.
We'll talk. Very good. Thank you. Bye-bye.
Thank you.